Well, it seems that I'm here again, dumbing myself down for you people out here who are just twisting and, you know, taking my sordid story and trying to make the YouTube dollars. So I got with Mo in the Deep End, and she told me I could use her channel for today to get my message out. I mean, how dare you all? I can't even use a typewriter, and I had to do little bubble letters of hand delivered. I mean, how dare I? How dare they? So, as you can see, I know my case number because I am, the only one that cares about uh my case, I guess. Uh, I styled my hair. Look, we don't have a great beauty team here. That's why I take care of my own look. But my name is Sarah Boone, and oh my God, Honorable Judge Michael Kranick, could we please worry about the justice that I have not received yet? Thank you, Debbie W. I'm sure Mo appreciates that she gets memberships while I'm stuck here in prison. I had to brew my own hooch. I mean, that I never drink. I don't want to drink. I like to drink, but I can't drink. You guys know me. Uh, Mads, Roxanne, Jeff, Great Success, and Elaine Riley were given memberships. So thank Debbie W. and thank you, Debbie W. Oh, star, regular correspondence. Look, I have fans from all over the world, North Korea, Tokyo, Boston. I mean, it's it's just terrible. And then I have legal correspondence because, you know, now the total number of pages that I had to write in duplicate was 58. Hopefully someone will pay attention to how the legal system is supposed to work because I put a lot of work in here and honestly it's a bit well low standards that this is what our justice system has become. Honorable Judge Kranick, ongoing 5 years dot dot dot. Why can't I dot 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 use my constitutional rights? Am I the only one that cares about the ongoing violations of, or have a bond? Have my medical records? Have all of my digital evidence and discovery? Have all my paperwork notes? Uh, Absolutely, Tammy, Lady Tammy. So, the too long didn't read of this story, Sarah Boone, the lovely woman that I'm pretending to be, well, she's a bit of an alcoholic, though she just says that she drinks for fun and she knows how to keep on top of things. However, she and her boyfriend were both toxic to each other and decided that one evening while they were drinking, they were going to play hide and seek. So Sarah put her fun-sized boyfriend into a Samsonite, kept him in there, even though she recorded him pleading for his life, saying that he couldn't breathe. Um, and unfortunately, she left them there all night. Now she either unintentionally or basically her premise is that this was a terrible accident and I have to live with this guilt, so not guilty because I didn't intend for him to pass away. Everyone else who understands and has a functioning brain understands that even if you didn't intend to unalive someone, if you taunted them as they were struggling for breath and didn't render aid, uh, that's called murder still. Especially it doesn't you don't have to uh, intentionally unalive someone, but if you fail to help and render aid when they're asking you or you leave them locked in a suitcase, uh, Now, Sarah has an unshakable feeling of rightness and purity and moral high standing. So she has been through eight, yes, eight lawyers who have tried to explain to her that, darling, just because you didn't intend for him to die, you're still going to get in trouble. But in Sarah's world, unintentional means not guilty, and none of her lawyers have been willing to tout this as a legal theory. I Yeah, it does seem like she intended to punish him, so it's it's not a great case. Someone lost their life, and she is now trying to pull, uh, the battered woman defense out. Now, they both seem to like to lay hands on each other when they were drunk, so I don't know if it was more of a mutual combat, uh, but they both had cases of DV against them. Now she has been f through 8 different public defenders because she's terrible and a horrible person to deal with. So she has written a 58-page letter to the 2nd judge involved in her case. The 1st judge, I think, recused himself because of how many times Sarah tried to contact him when truly defendants shouldn't be contacting the lawyer. She is insufferable to the max and uh, greatly believes that being a high school honor roll student. Uh, so, yeah, I'm sure I haven't read these 58 pages all the way through. She might have all my paperwork, notes, letters, pictures, everything of mine. This is my case. Returned by my former attorneys. Speak to my investigator. Have a complete download of my phone. Have any of my witness lists. Give any insight, understanding, clarification, truths about my case, especially to a new attorney. Be listened to by anyone, especially my new attorney. Be respectful for who I am truly, especially by my attorney, uh, and not be disrespectful or disrespected for the mutated and malicious murder all the world has falsely and incorrectly and believes me to be. Be treated fairly, lawfully, and protected by the justice system. Yeah, I mean, I'm still here in prison. I was a high school honor roll student. I don't think you know who I am, but I shouldn't even be in the justice system. Properly, rightfully, completely defend myself. I mean, I have been spearheading this case for 5 years, and no one has the legal smarts to keep up with me. It really is a sad commentary on our public defenders. Properly, rightfully, completely defend myself. See all and know the same as the world can and does, including my attorney, from all the phenomenal, non-permissive amount of my entire case being available online globally. I mean, I know I live in Florida and we have sunshine laws, but I thought you weren't allowed to lie on me. I thought you weren't going to lie on me like that. Just terrible. I had no idea that the entire state was working against me. Before I have seen it myself, I haven't even seen the stuff they've made about me. I am sure it is all glowing because it would be if they hadn't received a mutated and transmogrified, uh, you know, idea of what the case was because of, all of those internet creators trying to make a buck off of my story and my pain. Just terrible. What doesn't anyone already, quote, unquote, "know" about my case? How about my side of everything about everything? I know. I mean, you could hear everyone else's opinions or you could hear the truth from me. I mean, honestly, I don't know how I deal with people. He correctly understood that I am not, N-O-T, not the problem for reasons I am, uh, appointed, malappointed by the court, attorney number 8, see my letter from 7/21/23. I mean, I think I think we all know that this is a conspiracy against me. People are too scared of my intelligence and beauty. Say what I want and should, but all the world can and say all the wrong and warped. Why won't my attorney give me an honest answer? Show me everything she says she has and finished reviewing for my case, but withholds from me after I ask repeatedly for and about it. I mean, this woman is working for me. I don't understand. She doesn't put in the effort that I feel is, appropriate for my case. Give me an answer other than I'm putting this to rest. That's not necessary, or I'm not having this conversation with you. Grants me access to everything I ask for and in about my case. Like the detectives in my case, stop putting words in my mouth. Ma'am, no one wants to put anything near your mouth hole, but okay. Tell me what's going on in my case. It's been well over 100 days. 100. And she has been my attorney, and I still don't know, going on 5 years, answer all of my questions, ever ask me any questions. How can she supposedly know everything she needs to know from what she's been told, heard, read, and seen? No, not like she's been a public defender for 20, close to 30 years, Sarah. No, no, you are the, in fact, arbiter of Magna Carta that we need or we deserve, which I go more with deserve. Reassured she's on my side for me, not against. Why have I already been judged in the court of public opinion? Because video footage exists? I mean, I feel like Sarah's a little confused how she comes off to people. I mean, it could be me, but speaking Cantonese to everyone will get you ignored. Why have I been sentenced by anticipation and condemned before my predicted trial? Magic 8 Ball says, "You're a bitch." She needs an emotional support animal or nurse that's just like, "Hey, hey, be, be." Your Honor, during our first introduction at my last withdrawal of court-appointed attorney number 7, Mr. Hobson, you stated to me in your involvement with any of my letters I write. I am still going to write my letters as conductively? Oh, continually, uh, as they're my conduit. I don't know what this word she's trying to say, but that is not a word. I'm guessing her continuity or her ability to get her, uh, message across is how these letters are a PR campaign for her. It's almost like, being a PR person for nicotine in "Thank You for Smoking." I am still going to write my letters because they are my path to the world where my potential jurors are located, and this is the only way anyone including yourself, knows the very necessary insight that only I could provide to my continued disadvantages, hindrances, impediments I'm still experiencing on top of all the new spurring my intention to write. The race to the pulpit is unfair. Well, that would be in church, and I don't know that you should go in there without rubber-soled shoes, but, I think you mean judgment. And it's important to me that you are made aware and understand what transpires when the new cameras are off and we are all in between my status hearings. 2 are as many as of advantageous embezzlers, racketeers, mindless lemmings. Sarah, I always knew you saw me. Thank you. I'm doing good work here. Uh, and other altogether mean people can use their freedom of speech, not knowing me in any way other than what's being said by other mean people. Ma'am, have you met the internet? And being said incorrectly. Well, Sarah, my PO box is on my or on my YouTube. If you're feeling froggy, you can write me a letter too. I only promise to put it directly on my channel. So please tell me how incorrect I am because we did a legal shenanigans theater of you you might not feel so happy about, but I felt like it was truthful as compelling annoyed detectives in my case. Uh Kopeski had falsified documents and Lowen wore his gun for me to see. Mm, he practiced trigger control, so really, ma'am, I think you came out of that okay. I am sure you're familiar with after watching all of my plastered, highly misconstrued, over 30 plus million views just on one site, interviews and in which they both repeatedly attempted to feed me their incomplete, incorrect, hypothesized opinions, stating to me, quote, everyone has their limits, end quote. No, they were warning each other so they wouldn't commit, felony assault on you at their seemingly endless point of perpetually of nonsense and lawlessness still growing and very much I want to advance to the next level ongoing after 5 years now. I have a self-calculated equivalent to a Juris Doctorate, and I could be considered a lawyer now. I've done quite well according to me, I grade on a curve. A genuinely a genuine concerned limit has been reached. Why am I still not being included in my case? How much of more of my case and self is being added hourly, especially after this letter gets loose? Sarah, I again feel seen and thank you. God bless you for writing this 50-page manifesto of stupid. To the internet, increasing the mass infection and destruction of my hopes to have a fair trial. Anything fair, my side foremost, and wondering now if my attorney, quote, drank the punch just like everyone else. Sarah, maybe if you had stopped drinking, this whole layer wouldn't be necessary. But chink. All aforementioned reasons and so many more for this letter to be written, helping to deter some of the unfair, one sided finger pointing of corrupt and malpractice being directed at me only by those in the justice system who are trying to deflect the shame and shock from me fearlessly challenging the status quo. I am a warrior for wine and God. Mostly wine. I'm sure God'll just see how awesome I am and join the team. And it must be so because it is in my face on the computer at the same time on my boob tube television. Brainwashed, ignorant followers of disbelief. Well, I mean, no. See, I went into your interrogation. I saw it with my own eyes, and let's see, you came off as an uncaring, unfeeling mega thunder cunt. It's almost like I assessed on my own, little eyeballs and figured this thing out. Conformity and greed. Yeah, public defenders. Public defenders are the ones that are swindling you, Sarah, for the love of all these Cheetos. Trying unsuccessfully to make my life by character assassination seems worse than theirs. No, two, when anyone points their finger, one, it's impossible, and two, three point back at you. Am I now a mutant X person? I can point all of my fingers. In fact, I have two, a special two-finger salute since you've called me arrogant and stupid and well, I am greedy. Look, if I could get all the Sailor Moon BS that I wanted in all the wigs, totally, I'd get them. So there you go. Right from me to you. Love, Julie Newmar. How many tried it to see? Put the stone down, as there will be no casting of any today. Sarah, sweetie, come over here to Mama Mo. Sweetie, ma'am, you live in the glassiest of glass houses, okay? So, I'm not sure that this is a good thing, but okay, sure, ma'am, let's bring the Bible into it because 'cause I'm sure you've read it. For the role of my part, for all the pre-conclusioned, quote, documentaries and crystal ball real life stories of the crime incorrectly formulated from everyone supposedly knowing me and judging who they think I am. No, ma'am, I saw you. Uh, you speak fluent Cantonese and no one wants to deal with you. And if Elon Musk would get off his ass, we'd send you to Mars. Warning, Mo's leg may have been kind of an a-hole today, so I may be a little enhanced to making the cursey words flow. Let the let the curses flow through you. Come to the dark side. So there you go. But I do feel seen, Sarah. How many times have you watched Legal Shenanigans Theater? I'm just asking for a friend because it's got a really cool, catchy tune. I didn't have it back then, but I think you'd have fun with it, Sarah. Come on. Remember, 3 point back. Three. Try it yourself. If you point a finger at someone else, do finger, force multipliers. Then you only have three pointing back at you and a safe trigger guard. And soothsaying is not a real job. Well, I passed a psychic fair on the way here back home that I think well, they're going to be a little upset, and that might be real defamation. If you ask me, you might have been defamacating on their whole, entrepreneurial thing. So you might have a lawsuit coming up. To sum it up in the words of my attorney, after I told her to Google me, she stated, "There's a lot." To sum it up in the words of myself, the real person in charge of this case, the defendant, stated to my attorney after she stated to me, "When can I see? How much longer do I have to wait? Or how many attorneys must be withdrawn for me to be included in my case and be included more than the world pervert or presently is?" This is my case in every aspect. See my aforementioned ongoing 5 years questions that I'm still waiting for answers on. Also, I want to make it known I walked out on my attorney in our last meeting. How dare she treat me with disrespect, saying she's not going to answer my 13th question about the same thing? How dare she? Due to her unwarranted, uninformative, unprofessional, and snotty attitude, and her withdrawal or untruthful answers to my questions and beyond. The art-tarted, vicious circle we enter every time we meet is a waste of time. And Sarah, look, I guess if you are the thing, you can say it, but I don't have that pass. So there you go. But I wouldn't use that word unless you have that pass. Just saying. I mean, you're already kind of a trash bag human. Maybe not using the R word. I am saying that being in jail with supposed endless amounts of how she treats me is extremely prejudiced, hostile, and unconcerned. It's the greatest, you know, discrimination ever, one that affects me. Uh, she is serophobic. She is very frustrating. One, to talk or defeat in an endeavor. Two, to induce feelings of insecurity, discouragement, or dissatisfaction in. And three, to bring nothing. So much I presented my solution in order to coexist and work together in hopeful, progressive, positive, and appropriate manner. I mean, I gave her the list of AR rules that I made her. So, she just won't listen. I have, infractions on her, timeouts, everything. I don't know how to help her more. I added, quote, "pretend judge" to our interactions so she could calm down and ease up on her condescension, offensive demeanor, and obvious prejudgment. She seems like everyone else. Sarah, have you ever asked why everyone around you seems like a-holes? Because it may just be you. Just throwing it out there. The first step is admitting you have an a-hole problem. Not to remember I am innocent until adjudicated otherwise. She said adjudged, but, well, I mean, she's trying. She is at a doctorate level of legal scholarship, according to herself. She treats me as if I am not. After my introduction and explanation, for which the pretend judge in the room or on the phone, I'm trying to help her understand how she is making herself extremely unwelcoming. When in front of a real judge and in a courtroom is how she should treat me, her client. I pay taxes. No, you didn't. You lived off of your husband's alimony, but okay. Uh, I should not have to invent a pretend judge in order to be and not all at all wrong for wanting to be respected, no matter the outcome. I am innocent until adjudged otherwise. My attorney, everyone's, should be fair, unbiased, trustworthy, honest, supportive, informative, protective, automatically and effortlessly. Ma'am, would have to be high as balls to be collected with you. I should feel secure, highly confident, proud in her representing my life. I do not and have said to her many times regarding her monumental disbelief in me and my case, which I believe contributes greatly to her comical attitude towards me. And I'm hoping by this letter she will pick up the sword of injustice. What in the gee No, it would be the sword of justice. You are facing injustice. She would be wielding the sword of justice to get you out of this injustice if you were cognizant of the English language. And fight alongside, not against me, as so many unmotivated, overwhelmed, weak attorneys prior who bowed out gracefully and crept away from the battlefield unsuccessful. My case equals bizarre, equals unknown, equals different, equals ignorance, equals misunderstood, equals unfair. Sweetie, if you're wanting to, like, y'all, no, sweetie, I am the worst at equations. Once they added letters to math, I was like, who the hell created this form of torture? But that's not how an equation works. That is uh that is just a bunch of equals. Those would be synonyms, or, you know, there you go. The more you know. This doesn't mean my case can't, quote, equal success, and in more than one way, while everyone continues to ring their bells of malevolence. Oh my God, you guys, now I need a cowbell and, write malevolence on it or bedazzle it, and then I'm just gonna add so much cowbell during her trial. Bells of malevolence. I'm gonna come up with a dance. I mean, this is gonna be on fire. While I am clinging onto the hope of honor, possibility, boldness, listen, I am not a murderer. The justice system should equal fair, faith, trust, respect, innocence until and if adjudged otherwise. 3 points back. Sarah Boone. Holy Jesus. Heart confused cat meme. Yes, thank you. What in the fever dream am I reading? Oh, these are my notes from the meetings. June 4th, 2024. Video visit only 12 minutes long. In addition to my previous letter intended for hand delivery on 6/7/24, my new states or status hearing today, my attorney made a video visit to go over everything I've been asking her for and have also sent to her personally in 2 letters. Keep Sarah away from the damn stamps. Damn stamps. Oh my gosh. That sounds like an incredible idea, but I would be completely hammered, publicly buzzed. All on public video visitation box, where on both sides of me, less than 5 inches away from my new visit, was other inmates trying to have their visits too. I mean, can I just get my own room? I really feel like my case is more important than anyone else's. I have explained to my attorney numerous times previously in writing and verbally that despite the noise level, I do not have in any way feel comfortable having in-depth private meetings regarding my entire criminal case. I mean, really, the service around here is horrible. On the visitation box, where there is no privacy whatsoever, and held in an open bay dorm with more than 62 other interested, all ears inmates. Everyone is peanut butter and jealous of me, you guys. That's what's going on in this jail. Everyone is jealous of me. They want to be me because they know I am so smart. I cannot fully participate, if at all, from the entire dorm, an officer included, trying to participate also in my case. As always, my attorney did not listen or care after I repeatedly tried reminding her of my unsecure environment. Barking at me, I can, quote, listen or not. She works for me. How dare she? Still going, ever speaking, and not allow me to respond. Sarah, that's called a defense mechanism. When someone meets an emotional vampire such as yourself, what they will end up doing is forming a sort of immune response. They figure out that if she's talking, you can't, she can get all that she's, bound by professionalism to give you, and then she doesn't have to listen to you so she can hang up the daggone phone. After repeating to her over and over and over, 3 overs, 3. See, and I only have 1 finger pointing back at me now, so when you do a 3, you really should point with all 3 fingers. Just point with knife hand. Sarah, I point with knife hand, so none are going towards me. Nice try. While she is speaking beginning to speak louder and over me to still please schedule on an in-person meeting so where I can have a discussion further and privately with no success of being overheard. I disconnected the visit telephonically. She was uncooperatively she is impossible. See previous letter or ask her for a copy of the 2 I sent to her. I was trying to remedy this. I was trying to fix it for her. Or lesson before sending this to you, Your Honor, and not having to include new now it's a race to the pulpit. Again, Sarah, it's called judgment, not the pulpit. That's a part of church. Maybe you should go sometime. You might learn humility, or you might get struck by lightning. I mean, either way, it would be fun for me to see personal growth. My question, please, who acts like that and can still call themselves professional? The visitation box is primarily for family and friends to connect. Ma'am, not one of your A, I'm gonna X to doubt you have friends, and B, your family is probably okay with the respite, to be honest. And if a visit, a new ma'am, you had such good handwriting, and then some of them are just no idea. From an attorney, reminders, notices, quick questions, not high level confidential case information. She, like other former attorneys who always, always blame their dysfunctions on me, said, quote, "You don't like the answers I have to give you," end quote. What answers? See pages 1, 2, and 3, because I have a whole list bullet pointed out there of what this woman hasn't answered. I am not the problem. Full capital letters, except that I want to and should be treated fairly, with respect and acting more professional than the paid. I've been doing this for over 30 years. Professional. After so long and in all the experience, common courtesy, customer service. Oh, ma'am, you are not a paying customer. This woman is doing a service of martyrdom. And listening skills should have been acquired. All attorneys, do you even remember why you wanted to be one? Remind yourself. No one listens, and it works in everyone's favor but mine. That I am a murderer stuck in jail so they can pin on me their uninterested, unmotivated, hopeless, they're going to believe me over her attitude. I am not wrong for not thinking less of myself because everyone else has and does. This present attorney foremost. The justice system expects me and other inmates, aka clients, to accept its subpar, nonchalant, hypocritical, next on the list attorneys they keep aimlessly throwing darts for and malappointing, praying they don't withdraw. I have not fired any of my attorneys, pointed to my case. I didn't fire them, and I should be the only one that gets to fire someone. From me expecting the highest equal standards possible for wanting the absolute best outcome in my preposterous and mismanaged case, and representing myself is not an option, as both judges have now uh, treated me with from being outspoken and intelligent in all my observations of what's going on. I'm trying to help them. I am intelligent and I'm trying to lower my level to these idiots. I They don't accept my gifts of knowledge, intelligence, and observation of the ongoing abuse I am and have experienced. I have no new experiences from it always being the same. Blame Boone. I refuse to be moved or in wanting respect, no matter who thinks they. I am clarity, inclusion, honesty, and professionalism. She's going to start writing for BuzzFeed. This is going to be great. Uh, and another great reason not to have my case meetings on public visitation box is my personal confidential inmate information, such as my visitation list from 2020 to 2023 with names, etc., my interactions with inmates and officers, what I eat, when, and my personal jail calls also being thrown online. For what? To hate me more, to try to get others to because I don't eat breakfast or because I know some Latin and have short hair and my penmanship is nice? Ma'am, I'm gonna need you to step a little bit off of your high horse. It's only a pony and it's got short little legs. It's kind of the size of a Morkie. So get the hell out of here. Or because I'm not getting fat and sleeping all day, but rather fully applying myself, fighting still, making everyone upset from not having to fabricate and splice and edit. The world apparently knows all. What's next? How many times will I go to the bathroom and what function will I perform? No one knows anything. Not that it uh, seems to want to be seems to want to from being comfortable in their corruption and sitting on the top with ratings. Well, Sarah, I'm trying. Thank you for noticing. I feel seen. Web hits and money. I'm still waiting on the money bit, to be fair, but I'm hoping that, as you predicted, I will get those, Sarah Boone millions. My case details, if anyone forgot, and if you think about it, all that keeps getting plastered and plagiarized and posted and poked fun about me, it's all in my favor, proving myself right about all the mindless lemmings, shut ins, and the justice system. Hey, I'm not a shut in. I choose to stay in my comfy room. You heifer. You heifer. I like my room. I'm not a shut in. Thank you so much, Publicly Buzzed, for the Boon Bucks. Thank you. But I am not a shut-in, sir, ma'am. I I just like my room. Advantageously abusing and profiting from everything in my case or cases before my trial and before I've been seen. Ma'am, again, have you functioned with the internet before? Please be sure to read my attachment for FRCP Rule 3.220 subsection E. Resist or restricting disclosure. Am I the only one who thinks of these things? When can I win in anything? Well, when you stop being an overbearing thunder cunt, maybe the world and karma will change things. But it will require some introspection that isn't Sarah is great. Sarah is great. Sorry, youngest most feral. And the traitorous kitten who has joined the dark side of youngest most feralism was running through my room for some reason. I am not the problem, and if anyone were to, you know, slip on my slides and have to experience, tolerate, and deal with any of what I have and am, would bravely be doing the same. Sarah, the only thing I would kind of wish to pick up from you would be your unerring, just self-confidence that you are right. Oh. Don't knock it until you try it. 3-point back. Race to the pulpit. Always, always Sarah Boone. And there's more. West Florida statutes annotated Florida Rules of Criminal Procedure 3.220. Discovery. A. Notice of discovery. After the filing of the charging doc. I love how she's filling out these rules for people that work in the justice system. I, uh, I can't imagine that they wouldn't be aware of this, but okay. Has she read I mean, in her quest for a legal education, has she read about Florida's sunshine laws? They can't hide any of this. Uh, A defendant may elect to participate in the discovery process provided by these rules, including taking of discovery depositions by filing with the court and serving on the prosecuting attorney a notice of discovery, which shall bind both the prosecution and the defendant to all discovery procedures contained in these rules. B. Prosecutor's discovery obligation. 1. Within 15 days after service of the notice of discovery, the prosecutor shall serve a written discovery exhibit, which shall disclose to the defendant and permit the defendant to inspect, copy, test, and photograph the following information and materials within the state's possession or control. A list of names and addresses of all persons known to the prosecutor to have information that may be relevant to any offenses charged, or any defense thereto, or any simul fact or evidence to be presented at trial under Section 90.404, subsection 2, Florida statutes. B. The statement of any person whose name is furnished in compliance with the preceding subdivision, or the term statement as used herein includes written statement made by the person and signed or otherwise adopted or approved by the person, and also includes any statement of any kind or manner made by the person and written or recorded or summarized in any writing or recording. The term statement is specifically intended to include all police and investigative reports of any kind prepared for or in connection with the case, but shall not include the notes from which those reports are compiled. C. Any written or recorded statements and the substance of any oral statements made by the defendant, including a copy of any statements contained in the police reports or report summaries, together with the name and address of each witness to the statements. D. Any written or recorded statements and the substance of any oral statements by co-defendant. E. Those portions of recorded grand jury minutes that contain testimony of the defendant. F. Any tangible papers or objects that were obtained or belong to the defendant. G. Whether the state has any material or information that has been provided by a confidential informant. Sarah, you effing filmed yourself denying this man help to get out of a suitcase where he said he couldn't breathe. Your co-defendant is your cell phone, you dingus. H. Whether there has been any electronic surveillance, including wiretapping of the premises of the defendant or conversations to which the defendant was a party and any documents relating thereto. I. Whether there has been any search or seizure and any documents relating thereto. J. Reports or statements of experts made in connection with the particular case, including the results of physical or mental examinations. Oh, sweetie, therapist would have a day with you. Like, I have some, stuff I could probably use help with, but ma'am, you'd probably burn out Sigmund Freud with your bullshit. So, Godspeed to whatever psychologist has to interrogate you. Bring a flask. K, any tangible papers or objects that the prosecuting attorney intends to use in a hearing or trial that were not obtained from or did not belong to the defendant. L, any tangible piece or papers, objects, or substance in the possession of law enforcement that could be tested for DNA. And this heifer just wants her engagement ring she gave Jorge back. She's like, I will finally get that engagement ring back. M, whether the state has any material or information that has been provided by an informant witness. 2, if the court determines in camera that any police or investigation or investigative report contains irrelevant, sensitive information, inter something with other crimes or criminal activities, and the disclosure of the contents of the police report may seriously impair law enforcement or jeopardize the investigation of those other crimes or activity, the court may prohibit or potentially restrict the disclosure. 3, the court may prohibit the state from introducing into evidence any of the foregoing material not disclosed, at, so as to secure and maintain fairness and just determination of cause. 4, as soon as practicable after the filing of the charging document, the prosecutor shall disclose to the defendant any material information within the state's possession or control that tends to negate the guilt of the defendant as to any offensive charge, regardless of whether the defendant has incurred reciprocal discovery obligations. Sarah, we have you on effing video. There really isn't, exculpatory evidence. D, defendant's obligation. So this is one that directly affects her, as you can see starred and bolded. 1, if a defendant elects to participate in discovery either through filing the appropriate notice or by participating in any discovery process, including the taking of a discovery deposition, following the disclosures shall be made. Well, thank you for joining Publicly Buzzed and have a great rest of your weekend. A, within 15 days after receipt by the defendant of discovery exhibit furnished by the prosecutor pursuant to subdivision B1A of this rule, the defendant shall furnish to the prosecution a written list of the names and addresses of all witnesses whom the defendant expects to call as witnesses at the trial or hearing when the prosecutor subpoenas a witness whose name has been furnished by the defendant, except for trial subpoenas, the rules applicable to taking of deposition shall apply. B, within 15 days after the receipt of the prosecutor's discovery exhibit, the defendant shall serve a written discovery exhibit, which shall disclose to and permit the prosecutor to inspect, copy, test, and photograph the following information and material that is in the defendant's prosecution or possession or control. Sarah, these letters and your little picture that, was like, I'm not guilty, I am awesome. Those are not exhibits. Those are just your Well, you're floundering to try to find a way to get out of this, and you have yet to accept the reality that you are going to be in jail for some time because it is still a crime, even if it was unintentioned. I, the statement of any person listed in the subsection or subdivision. D, 1A, other than that of the defendant. II, reports or statements of experts that the defendant intends to use as a witness at trial or hearing made in connection with the particular case, including results of physical or mental examinations and of scientific tests, experiments, or comparisons. And any tangible reports, objects that the defense intends to use in the hearing or trial. Do not let this heifer get control of the damn suitcase again. She's not to be trusted. 2, the prosecutor and defendant shall perform their obligations under this rule in a manner mutually agreeable as ordered by the court. The filing of a motion for protective order by the prosecutor will automatically stay the times provided for this subdivision. If a protective order is granted, the defendant may, within 2 days thereafter, or any time before the prosecutor furnishes the information or material that is subject to the motion for protective order, withdraw the defendant's notice of discovery and not required to furnish the reciprocal discovery. E, restricting disclosure. The court is on its own initiative or motion of counsel shall deny or particularly restrict disclosures authorized by this rule if it finds there is a substantial risk to any person of harm, intimidation, bribery, economic reprisals, or unnecessary annoyance or embarrassment. Sarah, you are an annoyance and an embarrassment to humanity. We don't claim you. The rest of us can live in relative harmony with sarcasm. You, ma'am, can't people well. Resulting from the disclosure that outweighs any usefulness of the disclosure to either party. F, additional discovery. On a showing of materiality, the court may require such other discovery to the parties as justice may require. Sanctions. This heifer is going to try to get sanctions on the lawyers that ran away from her. 1, if at any time during the course of the proceedings it is brought to the attention of the court that a party has failed to comply with an applicable discovery rule, the court may order the party to comply with the discovery or inspection of materials not previously disclosed or produced, grant a continuance, grant a mistrial, prohibit the party from calling a witness not disclosed or introducing evidence in the material not disclosed, or enter such an other order as it deems just under the circumstances. 2, willful violation by counsel or a party not represented by counsel of an applicable discovery rule or order issued pursuant to thereto, shall be subject to counsel or the unrepresented party to appropriate sanctions by the court. The sanction may include, but are not limited to, contempt proceedings against the attorney or unrepresented party, as well as the assessment of costs incurred by the opposing party when appropriate. 3, every request for discovery or response or objection, including a notice of deposition, made by a party represented by an attorney must be signed by at least one attorney of record as defined by Florida Rule of General Practice and Judicial Administration 2.505 in the attorney's individual name whose address must be stated. A party who is not represented by an attorney must sign the request, response, or objection and list his or her address. The signature of an attorney constitutes a certification that the document complies with Florida Rule of General Practice and Judicial Administration 2.515. The signature of the attorney or parties continues a certification that the signer has read the request. response or objection that to the best of the signer's knowledge, the information or belief formed after a reasonable inquiry, it is A, consistent with these rules and warranted by existing law or a good faith argument existing law. B, and this is important to me, that's why it's starred, because I am a star, even if I am in prison, not interposed for any improper use or purpose, such as to harass or cause unnecessary delay or needless increase in the cost of litigation. Yeah, Sarah, I'm sure the state would love to be rid of you, but there's this thing called laws and rules and, due process that you are owed for being a citizen, if not a good person in this country. C, unreasonable or unduly burdensome or expensive given the needs of the case and importance of the issues at stake in the litigation. O. Pretrial conference. 1. The trial court may hold one or more pretrial conferences to consider such matters as will promote a fair and expeditious trial. The defendant must be present at any pretrial conference unless the defendant's presence is waived in writing or on the record by the defendant or by the defendant's counsel with the defendant's consent. 2. The court may set, upon the request of any party, must set a discovery schedule, including a discovery cutoff date at pretrial conference. Oh, Lord Jesus, Sarah, you're not using any of this right. And he knows. Oh, wait. Quote, the individual shall have the full protection in person and in property is a principle as old as common law, but it has been found necessary from the time to time to define a new exact nature excellence of protection. Political, social, and economic changes entail the recognition of new rights, and common law in its eternal youth grows to meet the demands of society. There, in very early times, the law gave remedy only for physical interference with life and property for trespasses uh, via arms, when the right to life served only to protect the subject from battery in its various forms. Liberty meant freedom, freedom from restraint, and rights to property secured in the individual to the individual and his lands and his cattle. What in the hell gobbledygook is this woman writing a treatise about our property laws, the Magna Carta, habeas corpus, animagies, and I'm sure transfiguration. Like, this is Chat GPD if I asked him to write my report on lawfulness. Gradually, the scope of those legal rights broadened, and the new right to life comes to mean the right to enjoy life, the right to be let alone. The right to liberty secures the exercise of extensive privileges, and the term property has grown to comprise every form of possession, intangible and tangible. Oh, okay, so she got this out of somewhere. She didn't make this up. Uh, Bulwer's Law Dictionary, 2012 edition. Well, I'm glad you've stayed abreast in the new society. What in the American Declaration of Independence do we have here? Oh my God, you guys. She's like, in order to create a more perfect union. What the hell? American Declaration of Independence, 1776. We hold these truths to be self-evident, that all men are created equal, but none more equal than me, Sarah Boone. In fact, I'm a little bit above, if you will, because I'm a lady. That they are endowed by their creator. Me, I know, Sarah. I know you didn't think I was a deity before, but with certain inalienable rights, uh, that among these are life, liberty, and the pursuit of happiness. Yeah, but Sarah, they didn't include in their right to suitcase one's boyfriend if they're getting a little mouthy. That to secure those rights, governments are instituted among men, deriving their just powers from the consent of the governed. The Florida Constitution 2024. We, the people of the state of Florida, being grateful to Pabst Blue Ribbon, mullets, and gators, and all the shenanigans. I'm just kidding. Uh, to God Almighty, our constitutional liberty in order to secure its benefits, perfect our government, in and secure domestic tranquility. Sarah, you have never lived in the zip code of domestic tranquility. I don't even know if if you have ever even attempted domestic tranquility. Maintain public order. You also seem to have a very interesting, ability to maintain public order by walking around soused to the gills at 9 a.m., but I guess you can pursue happiness however you want to. Uh, and guarantee equal and civil and political rights to all. Do ordain and establish this Constitution. Star, client, definition. A person who relies on the professional service of another. The client of an attorney is a person or entity represented and advised by the attorney. A client relationship commences for an attorney with an agreement with the performance of service in reliance on a request for representation or with a statement of representation on which the client relies. All attorneys owe a client a duty of zealous representation balanced by the obligation to serve justice and act as an officer of the court. Attorneys also have an obligation to keep the confidence of the client at all times and to keep the client informed of all matters related to the client's interest, to inform the client of law related to the client's affairs, and to defer to the client's decision, although the attorney has no obligation to the client to perform or refrain from any act contrary to the highest standards of professional responsibility to the law. Holy God. This one's important. I started. Attorney client privilege. One of the oldest recognized privileges for honest, equitable, confidential communications intended to encourage open, full, and frank communication between attorneys and their clients, thereby promoting broader confidence, correspondence in accordance to an appropriate observance of all law and the administration of justice. uh, quote, zealous advocacy. An attorney must respect each client to the fullest extent under the law. Sarah, she is doing that, but by again not committing felony assault on your ass, okay? I mean, just what in the actual and requires representation to the attorney's fullest abilities without violating the rules of professional responsibility. It requires not only presenting each argument required by a client to every institution in which that client has business, but also framing each argument in the strongest terms of law that greatly benefit the client while remaining faithful to the facts and the law itself. Zealous advocacy is a requirement of the oaths required by attorneys admitted to the success of the adversarial system of the justice. Disruptive, disrespectful, degrading, or any disparaging theatric is never an inclusion of zealous advocacy, and the use of such crosses the line from acceptable, forceful advocacy into unethical conduct. Bouvier Law Library, the 2002 edition. Star, attorney misconduct. It is a failure of an attorney to comport with the rules and accepted professional customs. Ooh, it looks like she ran out of a pen. Looks like this one's a little bit sharper, if you will. Uh, Customs of the bar and includes an act or omission of duty by an attorney that fails to perform appropriately the office of attorney or as an officer of the court, as a counselor and fiduciary of the client, or as a member of the legal profession. The scope of attorney's misconduct reaches also to the conduct of the attorney that is harmful to the appropriate reliance of the citizenry upon the law and legal profession. Attorney misconduct includes actions or omissions that enable others to cause harm, not just harm caused directly by the attorney, and not all the misconduct is subject to remedy or sanction, although a variety of forms of each exist. Misconduct may always be the basis for a client to remove an attorney from their duty of representation, as any other cause for the client's loss of trust and confidence in a lawyer, and the attorney's demeanor to determine whether a party's substantial rights are affected based on repeated or persistent objected to misconduct. The district court shall factor into its analysis of that motion by engaging in continued misconduct. The offending attorney has accepted the risk that the client's case may be influenced by said misconduct. Therefore, the district court shall give great weight to the fact that single instances of improper conduct that could have been cured by an objection and admonishment might not be curable when that improper conduct is repeated or persistent. Again, the law dictionary. I, you know, bless her sweet little heart, thinking these lawyers who had to go, I don't know, to law school don't know these things. Bless your heart, Sarah. I guess they wouldn't let her have a highlighter because she's having to star these things. To be honest, I don't think I'd trust Sarah with a highlighter. Duress, an unlawful threat that limits the person's independence of judgment or action, and any improper thereat or condition. Threat, sorry. Such as coercion that limits a person's ability to think or act independently, and the presence of destroys the independence required of the party to subject to. In order to constitute a voluntary consent, it must clearly appear that the search was voluntarily permitted or expressly invited and agreed to by the person whose right is involved. She's like, I was not. This is Sarah Boone hair, and Ghost, I have to re-dye my hair because the red I got, uh, it is fuchsia, and that's not a mauve color, so I will be re-dyeing my hair in the morning. In addition, the person must be cognizant of their rights in the premises, and consent must not be contaminated by any duress or coercion, and the government has the burden of proof. Oh Lord Jesus, she has gone to habeas corpus. This is important. She has a star. Habeas corpus, great writ, a review of the lawfulness of any person's custody or restraint by a government official. It is the process of judicial review of any person's detention, whether by formal custody, incarceration, or the continuing restraint by an office or agent of the government of a state or federal government. The right of review of custody by habeas corpus is a fundamental constitutional right. It is a bulwark of individual liberty, being used to free people by courts without legal authority or without having complied with the requirements of law. Habeas corpus is protected in the U.S. Constitution from interference. Star, a defendant who has been confined for 30 days after their arrest without trial shall be allowed a preliminary hearing upon application. Star, informal consent. Consent given with an appropriate knowledge after the person giving consent has learned all the information that would be reasonably required for the basis of a reasonable decision in any or in many instances, for an institution or professional to prove that decision the maker was sufficiently informed over a matter to give informed consent. The institution or professional will provide the information request to making such a decision in an informed way, but the provision of the information is not a legal requirement to receive informed consent unless a custom, statute, or regulation requires it. An attorney or other professional has an obligation to provide any person with adequate information and explanation of a proposed course of action and its alternatives for the person to know of the material risks of each before consenting. By definition, professionals and fiduciaries have similar obligations to their clients and to those with reasonable right to rely on their information or advice before consenting. The lawyer or professional or other professional shall one promptly inform the client of any decision or circumstance uh, with respect to which the client's informed consent, as defined by Rule 1.1, subsection E, is required by these rules. 2, reasonably consult with the client about the means by which the client's objectives are to be accomplished. 3, keep the client informed about the status of the matter. 4, promptly comply with reasonable requests for information. 5, consult with the client about any relevant limitation on the lawyer's or other professionals' conduct when they know that the client expects assistance not permitted by the rules of professional conduct or other law. Star legal ethics. Yes, she does. But she is also, again, sending to a lawyer, a man who had to navigate the legal system in order to reach his position, basic definitions that she got from a nearly 12-year-old book that has probably been updated. It's just the complete lack of comprehension that she is so out of her depths. I mean, she really thinks she's schooling them. Legal ethics, the professional obligations of a lawyer, including those codified by rule and body of uh, rules and standards of conduct that the legal culture imposes on its members. Ethical standards arise, as does their authority over the attorney, from the oath of the attorney, the inherent power of the courts to discipline lawyers before the bench, the culture of uh, profession, sorry, the standards of liability for fiduciaries and professionals under these rules. Legal ethics usually require attorneys to avoid conflicts of interest, to practice with diligence, to avoid frivolous, false, or fraudulent or harassing behaviors, to zealously represent clients, and to generally avoid the appearance of impropriety. A violation of legal ethics subjects the professional to sanctions from professional bar and courts. Again, Law Dictionary 2012 edition. Star. Equal protection of the law. Each law should treat similarly situated individuals as in a similar manner. Equal protection of the law is one manifestation of an ancient principle of equal justice under the law and is required in the U.S. Constitution by states under the 14th Amendment's Equal Protection Clause and by the national governments under the Fifth Amendment's Due Process Clause. Equal protection requires each law, whether it is a statute, regulation, order, or application of custom, to treat similarly situated people in a similar way. Star, abuse of process. No, Sarah, you are abusing the process. A claim for harm from the misuse of legitimate legal process. This is a claim that can be brought when a pleading or procedure is wrongly employed for the purpose of harassing or injuring the opposing litigants. Examples include filing a false affidavit, my new arrest affidavit has someone else's information listed and also an N, no, for domestic violence, then sworn to be true and corrected by Conley. Copesell, see impeachment document. The lead detective in my case. What other discrepancies have been made in my case? Making false claims, see interrogation video. Introducing fraudulent evidence, statements, assumptions, guesses. Pleading the abuse of process requires the movant to prove three elements: that the legal process had been initiated properly and with probable cause, the process was subsequently perverted to accomplish an ulterior purpose for which the process was not originally designed, and the perversion caused harm. Abuse of process involves the misuse of process already legally in pleas whereby a party attempts to obtain a result not proper under the law. The two essential elements of abuse of process, an ulterior purpose and unwillful act in the use of process not proper in regular conduct of proceeding. Star, interrogation, examination of a suspect. The process of inquiry by which police or other law enforcement seek information from a person suspected of a crime. Star, interrogation is distinctive from interviewed, uh, as titled on my transcripts, in that the police seek not merely information in general from the suspect, but also statements from the suspect that are either directly or indirectly incriminating. This may involve direct questioning or other action designed ultimately to elicit such an incriminating statement and is subject to due process of law without any compulsion of the kind. Interrogation, as conceptualized in Miranda's sense, reflects a measure of compulsion above and beyond that inherent in custody itself, referring not only to the express questioning, but also to any words or actions on the part of police other than those normally attendant to arrest and custody, that the police should know and are reasonably likely to elicit an incriminating response from the suspect. Custodial. Yeah, the star means it's super duper important, but they don't allow her to have highlighters, is my guess. Custodial interrogation. Interrogation of a person in the custody of law enforcement officials and is following a person's arrest or custody. The hallmark of custodial interrogation is that the person knows or that the person is in custody, has no freedom to leave. I didn't know I was in custody and couldn't leave. I was told by Keepsell to come pick up my phone. No warning of being interrogated again. Being custodial interrogation, the stakes of interrogation are higher than when a person is free to go, and any statement made in custody during is presented or presumed to be coerced under the Fifth Amendment. The Constitution distillate of Miranda is that self-incrimination flowing from custodial interrogation is ipso facto compelled self-incrimination because of the inherent coercion, the inherent compulsion of the custodial interrogation environment. Excited utterance. She wanted to celebrate her birthday too. Spontaneous declaration or spontaneous exclamation, an unthinking statement made at a moment of great surprise and stress. An excited utterance is a statement made during or immediately after the declarant is surprised by a startling event or condition, while the declarant is under the stress of excitement caused by the event or condition. I don't know why we have. Oh, she's marked where she's gotten fan letters from. Let's get all the places. We've got we've got Maine, we've got New York, we've got New Jersey, we've got Pennsylvania, Virginia, South Carolina, and North Carolina, Georgia, Florida, Indiana. It wasn't me. Michigan, Wisconsin, Minnesota, Missouri, Louisiana, South Dakota, Kansas, Texas, Colorado, Arizona, Nevada, California, Idaho, and Washington. And from Canada, from America, from England, it looks like. And I believe that is Japan for some reason. Although, why the hell you would? Publicity, exploitation, and saturation. United States map, page 1. Today, each star is a state where I have received correspondence via mail or message regarding my current case. World map, page 2. Today, each star is a continent where I've received correspondence via mail or message regarding my criminal case. The number grows daily. Most of the letters and messages are available for my review and understanding of the impact my case details being made readily available on the global internet is creating. Wrongful, ignorant, and hate, massive prejudgment before my trial. Get habeas and corpus right in here. I want them found. I, the defendant in my case, have not yet ongoing 5 years, fully reviewed or even seen all of my case details. Everyone in the world has already had the opportunity to do so themselves. The continuation of the obvious exploitation allows the world to keep pressing their incorrect, presumed, unfair theories, ideas, accusations, forcibly insinuating I committed criminal acts. It was unintentional, not criminal. You spelled it wrong. My present attorney says it is not necessary to receive a court order. I've been trying to obtain to download my case information to apply from the OCCD tablets. My former attorneys are withholding some of my case contents I have supplied to them and which have been all deemed lost. Many other items have been returned, not by myself, but to the next attorney, and which have been unable to be located to date. I am missing innumerable case items which I continuously request to be returned or obtained without success. Invasion of privacy, Supreme Court, and wrongful conduct. 1. Appropriation, the unlawful use of a person's name or likeness to obtain some benefit. Intrusion, physically or electronically intruding into one's private quarters. 3. Public disclosure of private facts, the dissemination of truthful private information which a reasonable person would find objectionable. Ma'am, are you also a furry? Asking for a friend. False light in public eye, publication of facts which place a person in false light, even though the facts themselves may not be defamatory. Star, to defame, to injure or destroy the reputation by libel or slander, anything that is defamatory. Okay, I got that from Fraud at Wrangler. He does. There is a particular dumbass that lives in Indiana who thinks it's not defamatory, but he says it defamatory, and just like substain, it has stuck. If, quote, it has the tendency to render the party about whom it's published contemptible or ridiculous in public estimation. Sweetie, you do that all on your own. There was no one making you be an absolute moron, during your investigation. You did that all on your own. Big gold star and absolute, special points for Sarah's participation in her own slander. Or hinder virtuous men from associating with him. An opinion can be actionable if it implies the allegation of undisclosed defamatory facts as the basis for the opinion. Invasion of privacy, false light. Publicizing some matter to create a false and harmful impression. False light is both a theory of invasion of privacy and in some jurisdictions an independent cause of action. arising when a person 1 gives publicity to a matter concerning another person that places the victim before the public in a false light. 2. That would be highly offensive to a reasonable person. 3. When the person or persons giving or creating the publicity either had knowledge of the false light that would be result of or acted in reckless disregard of the falsity of the publicized matter or the false light in which the other would be placed. In order to state a claim for, quote, false light invasion of privacy, the person need not prove that they have been defamed. Rather, it is enough that they're given unreasonable and highly objectionable publicity that it attributes to their character, conduct, or beliefs that the false and or that are false and is placed before the public in a false position. Quote, the line is drawn when the publicity ceases to be giving information to which the public is entitled and becomes a morbid and sensational prying. Oh, good God. Well, this is starred and she made little bubble letters. Public exploitation and saturation. My personal, individual, criminal case is being advantageously exploited and abused from all my significant life-saving suppressible case details, evidence, proof of being illegally obtained by coercion, trickery, distress, and confusion, and without my permission in any form, written or verbal, to anyone, then broadcasted, distributed, and hand delivered to the entire planet, states, countries, continents, containing all of my potential jurors, causing irreparable, erroneous falseness, greatly tainting my new jury pool altogether by forcibly attributing heavily influenced, incorrect, inappropriate motives, theories, and ideas. This obvious exploitation and invasion of my privacy is creating unnecessary, unlawful oppression. And it's the worst kind of oppression. It's the one that's directly against me, depleting all of my entitled opportunities to be given a fair, proper, successful conclusion of my case. A is prejudice is prejudgment. I have no idea. A something is prejudgment has already been made unfairly against me from the undeniable violations of my constitutional right and due process law as I taught myself, as a result of my entire case and personal life being publicly globalized before my rightful trial, which is lawfully, ethically, and should be without disadvantage and free from all partiality, deceitfulness, dishonesty made from said evident exploitation. Definitions collected from Bouvier Law Library, Merriam-Webster's Dictionary, Smart Communications Tablet. 1. Exploit. Definition. Unfair or irrational use, the taking of an unfair or unreasonable advantage over a person, thing, resource, or circumstance. Exploitation means an unjust or improper use of resources of a vulnerable adult for profit or advantage monetarily or otherwise of a person other than the vulnerable adult through the use of undue influence, coercion, harassment, deception, false representation, or false pretense. And ma'am, you are not a vulnerable adult. Yes, you suffer from like acme bulk store levels of self-aggrandizing thoughts and narcissism. Not that I'm a, doctorologist, but no one is exploiting you. No one. 2, abuse, a corrupt practice to a wrong use, to misapply or misuse, to pervert application to and for the wrong purpose. 3, significant, deserving to be considered, important, momentous, having meaning, likely to have considerable influence or effect. Suppress, the restriction of a person's action or speech to keep it from being known, to stop publication or circulation, to hold back. 5, illegal, not lawful or sanctioned by official rules, not according to authorized by law illicit. Yes, just like suitcasing George was. 6, coerce, to restrain, especially by law or authority, to repress, to compel or constrain to any action as to coerce someone to vote for a certain candidate. Trickery, deception by tricks and stratagems, fraud. Duress, the state of compulsion or necessity in which a person is influenced, hardship, pressure, constraint. 9, confusion. Ma'am, I'm sure you live in a constant fog of Sarah clown music. Maybe you should take this one to heart about yourself. To make mentally unclear or uncertain, to disturb the composure of, the state of being mixed or blended, to produce indistinctness or error, to cause or make disorder, tumult. 11, broadcast, scattering in all directions, to spread widely, make widely known, or ever or to ever wide area the transmission of sound or image by radio or television, cast or dispersed in every direction. 11, distribute, to divide among several or many, to deal out a portion, a lot, to spread out. Deliver, to send uh, to an intended target or destination, convey, transfer, to release, to give, or to yield possession or control of, to make over to the knowledge of another, to give forth in action or exercise. Irreparable, impossible to make good, undo, repair, or remedy, not reparable, not capable of being recovered, regaining, irretrievable. Yes, but sweetie, come here. Now, look, I am a grammar outlaw, but I am a vocabulary uh, bigot, if you will. And you're not supposed to use the word to define the word. Stop. Stop. Just stop. Erroneous, incorrect, wandering, straying, deviating from the right course, misleading, and mistaken. You resemble all of those words, Sarah. Maybe you should take that to heart. Some people have live, laugh, love. You can have, erroneous and narcissism. Falseness, not genuine, artificial, intentionally untrue, adjusted, or made as to deceive, tending to mislead, inaccurate, based on mistaken ideas, contrary to fact, double dealing, pertify. Dang it. I know how to say that word, I just can't say it today. Taint, my favorite of the bad words. Corrupt, contaminant, to affect or become affected with something bad, a contaminating mark or influence, to imbue with something extraneous, especially with something poisonous. Force, strength or energy of an exceptional degree, active power, capacity to persuade or convince, an influence that causes uh, motion or a change of motion. Influence, the act or power of producing an effect without apparent force or direct authority, the power or capacity of causing an effect in an indirect or intangible way, to sway, to have an effect on the condition or development of, by a gradual process, controlling power quietly uh, executed. Incorrect, not correct, not according to established rules, inaccurate, faulty, not in accordance to copy or needed or testimony, not true, wrong, inappropriate, fitted to a wrong purpose or use. Motive, something as a need or a desire that it causes a person to act, that which produces conception, invention, or creative in the mind, a guiding or controlling idea, or Relating to motion. Invade a warlike or hostile entrance into rights, possessions, or domain of another, trespass to enter for conquest, or plunder to spread through and harm. And thank you for Hella Raid coming in. Privacy. The quality or state of being apart from others, security, a place of seclusion from conspiracy or observation. I mean, ma'am, everyone would like privacy from you. Welcome, Raid. Good, good. Well, I guess it would be morning for you. So good morning, EU, and I hope you had a great birthday. Oppression, hardship, or injustice, to impose excessive burdens upon, to overload, to threat with unjust rigor or cruelty, to crush by abuse of power or authority, to weigh down, persecute, wrong. Deplete, to reduce by destroying or consuming the vital powers of the exhaustion of strength or resources, to empty or unload. Entitle, to give a right or claim, to qualify for, to furnish with grounds for seeing or claiming with success, to attribute or ascribe. Fair, conforming within the rules, free from obstacles or hindrances, unobstructed, characterized by honesty, impartiality, without any suspicion, bias, or any marked characteristic. Proper, marked by suitability or rightness in all aspects, appropriate, excellent. Successful, resulting in success, accomplishing what was proposed, favorable or desired outcome, the result of undertaking effort or endeavor. Prejudgment, to judge before hearing or full and sufficient examination, to decide or sentence by anticipation, to condemn beforehand. Unfair, marked by injustice, partiality, deception, unjust, not fair, not or honest, disingenuous, using or involving trick or artifice, unequal, undeniable, plainly true, incontestable, unquestionable, not deniable. Again, sweetie, we don't use the word in definition. Indisputable. Violate, break, disregard, interrupt, or disturb, to abuse, infringe, non observance, the violation of law or positive command of covenants, promises, anything that should be held sacred or respected, and the contemptuous treatment of. 34. Constitutional rights, a right protected under the Constitution of the United States of America, and newest contemporary sense of a right, which implies a greater emphasis on the idea that the right is conferred upon the person by the Constitution, and without a Constitution, the person would have no rights. The enforcement of constitutional rights is a matter not only for the courts, but all branches of government also. Liberty right, a constitutionally protected ability to engage in certain, well, look, y'all, she had to change pens again. The constitutionally protected ability to engage in certain conduct or hold certain status, and in doing so to be protected from interference by police or agents of the government, unless that interference is well justified and legal. The right to privacy and freedom of speech are examples. Privilege or positive right, sometimes called a claim right, the constitutionally protected ability to call upon agents of the government to assist in performing certain conduct or hold certain statuses, and in doing so to be protected from interference by other government agents and and by private parties. Procedural right, the constitutional requirement enforceable by the citizen that the agents of government act only in certain ways, according to certain rules, and in consultation and agreement with another. The rights to laws made accordingly to specific procedures, to trial by jury, and to be free from torture are examples. Sarah, what about all of the torture that, I mean, yes, I do. It is I am terrible with this, so I have to always go and look at my name, which should be a little bit, uh, well, shenanigans filled, but it is, uh, at Mo in the Deep. If, one of the mods, if you can, if you could put up a link to that, but yes, I do have a Twitter. I just rarely use it for anything more than, to, well, put up, like, "Hey, I'm gonna be somewhere," or, "I'm gonna be doing a stream." But yeah, let me put that up there. I'm trying to get better at, computering. Fundamental to all these rights is a constitutional right in each individual that the agents of the government will abide by the Constitution and will do nothing through power of the state that is not allowed to them to do by the Constitution. The right not to be taken for unlawful purpose is an example. 35, due process, constitutional rights in life, liberty, and property interests that cannot be burdened without due cause or appropriate procedures. Due process of law is fundamental aspect of law, including not only the process by which the law needs uh, or must be created and applied, but also the scope within which certain laws must be made and enforced, and beyond which the laws ought to leave individuals to their own liberty. The Due Process Clause of the 14th Amendment prohibits state governments from depriving any person of life, liberty, or property without due process of law. Thus, due process of law includes both a procedural and substantive aspect. No, this is page 54. This is page, so she's divided this manifesto, if you will, into whining about lawyer, uh, telling the judge about things, copying down the letter or the Declaration of Independence. So this is all of her definitions just to send to the judge to explain to him what constitutional law and process is. I know you guys are shocked, but Sarah believes that she is schooling this man. Procedural due process rights are meant to protect a person from mistaken or unjustified deprivation of life, liberty, or property, and entitles a person to an impartial, disinterested tribunal in both civil and criminal cases, protecting two central concerns: the prevention of unjustified or mistaken deprivations and the promotion of a participation and dialogue by affected individuals in the decision-making process. Substantive due process rights are the fundamental rights and liberties which are objectively deeply rooted in a nation's history or in this nation's history and tradition. They are those rights implicit in the concepts of ordered liberty. No man of what estate or condition, no matter of estate or condition shall be put out of land or tenement, or nor taken, nor imprisoned, disinherited, put to death, without being brought in answer by due process of the law. Analysis of either a procedural or substantive due process claim must begin with an examination of the interest allegedly violated and the possession of a protected life, liberty, or property interest is a condition precedent on any due process claim. Publicize, to bring to public attention, to advertise. Rightful, having the right or just claim according to established laws, belonging, held, or possessed by right, constant to justice. Lawful, permitted, constituted, or authorized by law, rightful, legitimate, competent. Ethical, conforming to accepted and professional standards of conduct or of or belonging to morals, treating of the moral feelings and duties according to, in harmony with, moral principles or character. Disadvantage, an unfavorable, inferior, or prejudicial condition, quality, or circumstance, unequal portion in society, or loss or damage, especially to reputation or finances. Absolutely. Thank you for joining in and get a good night. Yes, I will be with Baker on the Karen Reed trial, and then I also do Newsy News at 8 a.m. It's about a 1 hour stream of just kind of news that isn't overly political or involving anything with any of the conflicts around the world. Sometimes, sad, sometimes, happy, sometimes completely odd. But yes. Well, yeah, she's kind of diminished capacity. I was drunk is seeming to fade for her. Partiality, inclined to favor one party in a cause or side of a question over another, biased, not indifferent, having a predilection for, inclined to favor unreasonably, special uh, tax or liking. Deceit or deceitful, an attempt or disposition to lead into error, any trick, collusion, contrivance, false representation, or underhanded practice used to defraud another, fraudulent, causes to believe what is false, entrap, seduce by artifice, mislead, dishonesty, void of integrity, faithlessness, disposed to cheat or defraud, violation of trust or justice, untrustworthy, want of fairness, to betray, evident, clear the vision. Clear to the vision and understanding, satisfactory to judgment, apparent. Excited utterance are admissible evidence despite both the hearsay rule and confrontation clause because they are only admissible when the circumstances of the statement are sufficient to demonstrate that the statement was unthinking, unplanned reaction to events. To introduce an excited utterance, the proponent must demonstrate that the statement was made during or following a startling event or condition, that the statement was made while the declarant was under the stress of excitement caused by the event. Sweetie, your entire interrogation cannot be an excited utterance. D Yeah, unintentionally is just your form of Tourette's at this point. It it's not an excited utterance. You had you can't have 2 hours of excited utterances. That's not how any of this works. The manner in which the excitement is caused may be direct, as in the declarant is a participant in an event or witness to it, or indirect, as when the declarant learns of the event later. By definition, a statement may be an excited utterance and not perfectly contemporaneous with the event, but it must be made while the emotional state caused by the event or condition persists. Many, though not all, statements that are excited utterances are also forms of statements or present in sense impression. Coercion, unlawful force, fear, or threats used to spur another to conduct. It is in the influence, compulsion, or restraint that diminishes. Oh, poor girl, she ran out of lined paper, or they really, really used a bad scanner. Uh, causes them to do or to refrain from doing anything. It is the basis for the crime of criminal coercion, which is a form of blackmail. Freedom of Information Act, FOIA. The stars, sorry, uh, So the stars, I don't think they let her have highlighters, but these are things that directly apply to her case in her mind. A federal or state statute requiring the government agencies to release information on request. If a statute requires the dissemination of information held by government agencies through regular publication of such information or by the release of such information only by request. The 9 categories of government information exempt from Freedom of Information Act are 7 law enforcement records if their production could reasonably be expected to interfere with enforcement proceedings, to deprive a person of a right to a fair trial or an impartial adjudication, to constitute an unwarranted invasion of personal privacy, to endanger the life or physical safety of an individual. Sarah, they are required to give out this uh well, because I'm supposed to look like Sarah, but I will go ahead and show you guys since we are at the end of her manifesto, her see you next Tuesday festo. I may have picked the wrong daggone dye this time because my hair is what we like to call fuchsia. Yes, fuchsia. So I will be going out to get a different hair dye tomorrow because what in the highlighter is this hair? It was supposed to be a deep red color and it turned into, oh my, uh, Bob. And Jung, she got most of her information from not Black's Diary, but Bouvier or Law Dictionary, the 2012 edition, Webster's Dictionary, because we know she loves that, and I think the YouTube. Yeah, this is not a I feel like poison ivy, but not in a great way. So I will be toning this down by the power of Clairol. The power of Clairol compels me. But yeah, I was kind of glad I got to wear a wig. I don't know. This woman got letters from South Korea or North Korea or somewhere. Yeah. Um, the most hilarious thing would have had to have been when the book that she was copying from told her that, one must stay abreast of all new laws and things because the law is ever changing, malleable to the current, society or the needs of a growing or, progressing society. And she then put 2012 edition. And I'm like, yeah, no, I'm sure no laws have changed in 12 years. That didn't happen, I'm sure. Anyways, guys, I am going to let you go. Let's see if there is someone that is currently going on. I know that I think Baker is doing a panel about not Sarah, sorry, Karen Reed. So if they're still going, I will probably send you there. I know that there were supposed to be a bunch of people that they were inviting, so kind of incorporating disparate parts of, law tube, crime tube, whatever this amalgamation of people that love um, trials. So he is going on. They are doing a panel with people that have been following the Karen Reed case for forever. And I think Valhalla's there. So I'm going to let you go to that. I'm going to go get some dinner and I will see you bright and early tomorrow at 8 to continue Newsy News and then the Karen Reed defense, the next bit of defense. I love it. I will see you guys tomorrow and have a great evening. Bye, guys.